Welcome to the lecture series on employee relations and labor laws. Today we will discuss about the Payment of Minimum Wages Act 1936. Now, this act basically is to provide for fixing minimum rates of wages in certain employments, whereas it is expedient to provide for fixing minimum rates of wages in certain employments. This act may be called the Minimum Wages Act 1936 and it extends to whole of India. Now, we will discuss about various interpretations used in the act. Now, first of all, it is adolescent. Adolescent means a person who has completed his 14th year of age, but has not completed his 18th year of age. Now, it is adolescents are included in this act as the minimum age for working in India is 14 years now. So, adolescents are included in minimum wages act. Now, next is appropriate government. As we all know, it is basically dependent upon the jurisdiction of the government or the authority. So, in relation to any scheduled employment carried on by or under the authority of central government or a railway establishment, or in relation to a mine, oil field or major port, or any cooperation established by central government, the central government will be the appropriate government, and in relation to any other scheduled employment, the state government will be the appropriate government. Now, next is competent authority. As we are studying from previous so many acts that all the acts have been provided with certain authorities to take decisions, to regulate the or to exercise various provisions provided in the act. So, here also we have competent authority, and competent authority means the authority appointed by appropriate government by notification in its official gazette to ascertain from time to time the cost of living index number applicable to the employees employed in the scheduled employment specified in such notification. Now, scheduled employment means an employment specified in the schedule or any process or branch of work forming part of such employment. Basically, scheduled employments are those employments which are scheduled under the Minimum Wages Act. In those employments, all the provisions provided by the Minimum Wages Act are regulated. Now, cost of living index number. Now, basically when we talk about Minimum Wages Act, now Minimum Wages Act basically dependent upon the cost of living index number. So, what is cost of living index number? In relation to employees in any scheduled employment in respect of which minimum rates of wages have been fixed, means the index number ascertained and declared by the competent authority by notification in official gazette to be the cost of living index number applicable to employees in such employments. Now, next is employee. Employee is any person who is employed for hire or reward to do any work, skilled or unskilled, manual or clerical, in a scheduled employment in respect of which minimum rates of wages have been fixed. All employments which are regulated under this act only will be all employees doing such employments will be regulated with this act only. Now, next is employer. Any person who employs, whether directly or through another person, or whether on behalf of himself or any other person, one or more employees in any scheduled employment in respect of which minimum rates of wages have been fixed under this act, and includes except in subsection 3 of section 26. Now, basically when we talk about employee or when we talk about employer, all organizations which are regulated or where this act is all those employments which are scheduled under this act only will be included in these all parameters. Now comes the wages. As you all know, we have studied wages in a detailed manner in Payment of Wages Act. Here also we will study wages. Basically, we elaborate wages as per the act we have been asked. Now, wages means all remuneration capable of being expressed in terms of money, which would, if the terms of the contract of employment express or implied were fulfilled, be payable to a person employed in respect of his employment or of work done in such employment. Now, if we talk about wages, we do study three kinds of wages: living wage, fair wage and minimum wage. Now, minimum, we are talking about minimum wages. Now, minimum wages are lowest wages in the scale below the efficiency of worker. Fair wages are between living and bare minimum wages, and living wages are appropriate for normal needs of average employee. So, if we want to discuss these kind of wages elaborated way, we will discuss elaborate in the way that living wage is a wage sufficient to ensure the workmen food, shelter, clothing, economic comfort, provisions of able days, etc. According to Fair Wages Committee report, the living wage should enable the earner to provide himself and his family not merely the basic essentials of food, clothing and shelter, but a measure of comfort including education for the children, protection against ill health, requirement of essential social needs and measure of insurance against old age. So, basically living wages are wages which fulfill the basic which fulfill basic requirements as well as to provide comfort to the workers and his family. Now, minimum wages may be defined as the lowest wage necessary to maintain a worker and his family at the minimum level of subsistence, which includes food, clothing and shelter. When the government fixes minimum wage in a particular trade, the main objective is not to control or determine the wages in general, but to prevent the employment of workers at a wage below an amount necessary to maintain the worker at the minimum level of subsistence. Now, basically to survive, the bare minimum requirement of the worker can be fulfilled by the minimum wages. Now, fair wages are something more than the minimum wages. Fair wage is a mean between the living wage and the minimum wage. The fair wages dependent on minimum wages, capacity of industry to pay, prevailing rates of wages, productivity of labor and level of national income, etc. So, basically certain levels have to be maintained to maintain fair wages, and these fair wages are dependent on minimum wage, which are prevailing rates of the wages in the industry, then capacity of industry to pay the wages and productivity of labor and level of national income. Now, comes the main provision of the act, which is fixation and revision of minimum rates of wages. Now, basically the appropriate government shall in the manner hereafter provided that the appropriate government fix the minimum rates of wages payable to employees employed in an employment specified in part 1 and 2 of the schedule of the act. Basically, this schedule has provided with part 1 and 2, wherein they have provided certain employments which are covered under this act. So, all those employments and the minimum rates of wages, fixing of minimum rates of wages are done according to the act. And those employments which are provided in the act under part 1 and 2. Now, further can revise and review at such intervals as it may think fit, such intervals not exceeding 5 years. Now, these wages, minimum wages are revised or fixed again and again between in various intervals and those intervals should not exceed 5 years of time. However, it was recommended that the revision should be made within 2 years or in a rise of 50 points in the consumer price index, whichever is earlier. Now, minimum rates of wages, section 4. The minimum rate of wages fixed or revised may consist of the following. Now, this consists of basic rate of wages to be adjusted in accordance with the variations in the cost of living index number, basically variation in the cost of living index number. Then basic rate of wages with or without a cost of living allowance and a cash value of concessions in respect of essential commodities supplied, and all inclusive rate allowing for the basic rate, cost of living allowance and cash value of concessions. Now, if we talk about minimum rates of wages, the minimum rates of wages includes all these 3 items. Now, comes the procedure for fixation and revision of minimum rates of wages. This is basically section 5, which talks about the process through which fixation or revision of minimum rates of wages been done. Now, in fixing minimum rates of wages in respect of any scheduled employment for the first time under this act, or in revising minimum rates of wages of so fixed, the appropriate government shall. Now, what appropriate government do for the fixation or revision of the minimum rates of wages? They may appoint as many committees and subcommittees as it consider necessary to hold enquiries and advise it in respect of such fixation or revision as the case may be. So, basically what they do, they appoint committees and subcommittees to hold on enquiries on revision or fixation of the minimum rates of wages, and these committees and subcommittees are appointed by notification in the official gazette, publish its proposals for the information of persons likely to be affected thereby, and specify a day not less than 2 months from the date of the notification on which the proposals will be taken into consideration. Basically, what they do, they publish a proposal for the for all those people who are affected with this act, or who will be affected by the fixation or revision of the rates of wages under minimum wages act. They will be called for proposals, and they have been given the 2 months time to give their proposals on the revision of the revision or fixation of the minimum wages. Now, all those who are affected by the by this act means all employments who are fixing or revising their rates under minimum wages act. All those people are affected by the revision or fixation of the minimum rates of wages. So, they will be called for the proposals for the revision and fixation of the wages. After considering the advice, the appropriate government will by notification in the gazette fix or revise the minimum rates of wages. Now, after 2 months for 2 months they will invite the proposals from the people who are getting infected with the revision or fixation of the rates. So, they will give their proposals to the appropriate government, they will advise, and after considering the advice by the appropriate government, they will notify in the official gazette and fix and revise the minimum rates of wages as the case may be. Now, next is advisory board, that is section 7. Now, basically advisory board is to advise the committees and subcommittees for fixation and revision of the minimum rates of wages. Now, the act empowers the government to constitute advisory board comprising equal number of representatives of employers and employees in the scheduled employments. Basically, scheduled employments are what employments which are coming under the act, where fixation or revision of minimum wages are being done by the under this act. So, all those employments are called scheduled employment. So, advisory board is consisting of equal number of representatives from the employer and the employees, and what they do to coordinate the work of committees and subcommittees appointed by it for fixing and revising the minimum rates of wages. Now, what they do? They coordinate the work of committees and subcommittees, which we have studied previously in the procedure. They will be appointed committees and subcommittees, and these committees and subcommittees are appointed to coordinate the appointed to fix and revise the minimum rates of wages. Now, advisory board may lay down procedure for discharging its functions. Now, next is central advisory board. This is section 8. Central government can constitute a central advisory board for advising the central and state governments in the matter of fixation and revision of minimum wages and to coordinate the work of advisory board. Now, central advisory board is basically a central body which coordinate the work of advisory board. Now, composition of committees. Now, we have in last here in procedure of fixation, we have studied about appointment of various committees and subcommittees. So, what is the composition of committees? Each of the committees or subcommittees and the advisory board shall consist of persons to be nominated by the appropriate government representing employers and employees in the scheduled employments, who shall be equal in number, representatives from workers and representatives from employees, employers, they are equal in number in the advisory in the committees. Independent persons not exceeding 1/3 of its total number of members, one of such independent persons shall be appointed the chairman by the appropriate government. Now, in those committees and subcommittees, 1/3 members will be the independent persons, and they will be one of them will be appointed as the chairman or chairperson of the committee. Now, correction of errors. This is section 10. The appropriate government may at any time by notification in official gazette correct clerical or arithmetical mistakes in any order fixing or revising minimum rates of wages under this act, or errors arising therein from any accidental slip or omission. So, basically if there is any correction, mathematical or clerical correction is there, they can do, and they can go for errors arising therein from any accidental slip or omission also. Now, every such notification shall as soon as may be after it is issued be placed from the advisory board for information. Now, all these information will be sent to advisory board. Now, wages in kind, basically minimum wages payable under the act shall be paid in cash, where it has been the custom to pay wages wholly or partially in kind, the appropriate government being of opinion that it is necessary in the circumstances of the case may by notification in the official gazette authorize the payment of minimum wages either wholly or partially in kind. We have studied in Payment of Wages Act that every person who is authority within the industry or factory is responsible for the payment of wages. Now, here if we talk about minimum wages, they are payable in cash, as we had already studied in Payment of Wages Act that all payments will be done in cash, and if there is any custom of paying the wages in a whole or wholly or partially in kind, so the permission should be taken from the authorities. If the appropriate government is of the opinion that provisions should be made for supply of essential commodities at concessional rates, the appropriate government may by notification in the official gazette authorize the provision of such supplies at concession rates. So, that does mean that concession rates commodities, if provided by the government, those commodities will be supplied in concessional rates other than the payment of wages. The cash value of wages in kind and of concessions in respect of supplies of essential commodities at concessional rates authorized under subsection 2 and 3 shall be estimated in the prescribed manner. Those whatsoever concessional rate commodities they have been provided by the appropriate government, it shall be estimated in prescribed manner in the act. Now, payment of minimum rates of wages. Where in respect of any scheduled employment, a notification under section is in force, the employer shall pay to every employee engaged in a scheduled employment under him wages at a rate not less than the minimum rates of wages fixed by such notification for that class of employees in the employment without any deductions except as may be authorized within such time and subject to such conditions as may be prescribed. And all authorized deductions we have studied in Payment of Wages Act, and all those authorized deductions can be made from the wages of the employees. Other than those authorized deductions, if any deduction has been made, that deduction will be deemed as illegal deduction. Nothing contained in this section shall affect the provisions of Payment of Wages Act 1936. So, this is in regard to deductions made in the deductions made from the minimum wages of the workers, which we have studied under Payment of Wages Act. Now, fixing hours of work. In regard to any scheduled employment, minimum rates of wages in respect of which have been fixed under this act, the appropriate government may fix the number of hours of work which shall constitute a normal working day inclusive of one or more specified intervals. These working days should be inclusive of all intervals also, which we have studied under Factories Act. And appropriate government may provide for a day of rest in every period of 7 days, which shall be allowed to all employees or to any specified class of employees, and for the payment of remuneration in respect of such days of rest. And also appropriate government provide for payment for work on a day of rest at a rate not less than the overtime rate. Now, wages for overtime. Where an employee whose minimum rates of wages is fixed under this act by an hour, by the day, or by such a longer wage period as may be prescribed in the act, works on any day in excess of the numbers of hours constituting a normal working day, the employer shall pay him for every hour or for part of an hour so worked in excess at the overtime rate fixed under this act, or under any law of appropriate government for the time being in force, whichever is higher. Basically, overtime rates we have studied under Factories Act. So, any worker who had worked for overtime, he will be paid according to the act. Now, wages for worker who works for less than normal working day. Now, if an employee whose minimum rates of wages have been fixed under this act by the day works on any day on which he was employed for a period less than the requisite number of hours constituting a normal working day, be entitled to receive wages in respect of work done by him on that day as if he had worked for a full normal working day. That does mean if the worker has not worked for 9 hours a day or he has been provided with the work for less than 9 hours, he will be deemed as he had worked for full working day and he will be paid accordingly. Provided that, however, that he shall not be entitled to receive wages for full normal working day in case where his failure to work is caused by his unwillingness to work and not by the omission of the employer to provide him work with work, and in such other cases and circumstances as may be prescribed. If he has if the worker has not worked willingly, he has been provided with the work, but he has not worked willingly for full working hours, then in that